informed the Attorney General you were available to meet. Was there a meeting?
Yes.
And can you put a time limit on time area for us as to when this meeting occurred?
It was in the middle of May, and the reason that I believe that the 55th day, so we would have been discussing it in the middle of May before it was released on June 2nd.
Now, you made a minute. Was there already a draft opinion regarding the matter that was intended to be issued before July 1?
Yes.
Or was it June 1 or July 1? I've got...
June 2nd was the 55-day deadline.
And what was the preliminary opinion that already existed in the file when you started looking at it?
It was to withhold the information under the law enforcement exception.
Now, when you told the lieutenant, the Attorney General that you were available, how soon did you meet with him, if you did?
It would have been a matter of days between notifying him and scheduling a meeting in his office.
You met with him in his office?
Yes.
All right. Was anybody else present in the meeting?
There were a series of meetings at which Justin Gordon, the chief of the Open Records Division, and Ryan Bangert attended.
All right. So at this first meeting, were they both present?
I don't recall if both were present, but there were just in this meeting and the subsequent meeting, one or the other.
What did the Attorney General say in this meeting?
He asked us to review the file. He asked us what our interpretation of the file was. He told us that he had spoken personally with Mr. Paul. He said that he believed that something bad had happened.
Now, in your experience and your familiarity with this subject, what was your response to that?
Objection, hearsay.
It's not. This is the witness. This is his response. Thank you.
I told General Paxton that if we were to reach the opposite conclusion and to require the Department of Public Safety to release the information, it would upset decades of precedent involving the law enforcement privilege, where law enforcement agencies rely on the protection that the Public Information Act gives it to protect ongoing information, to protect confidential information, to protect witnesses who could be compromised if their names or their identities were released. So there's incalculable problems with reversing the decision to withhold the information and require it to be produced, not just across the state, but with the Office of the Attorney General.
Mr. President, if I may.
Cooperated with the police, thinking that would be confidential.
It could silence people who might ordinarily comply or speak to the police if suddenly their names or identities could be released.
So what was the Attorney General's reaction when you told him all? But first of all, the stuff that you just said, is that essentially, in a sense, the information you gave him in explaining what your position was?
Yes, sir.
Did anybody else speak up as well?
Objection, hearsay.
I asked if anybody else spoke up. That is not thank you. Did anybody else speak up?
Ryan Bangert also spoke. I don't recall exactly what he said, other than that.
And what was the Attorney General's reaction to all this?
He, again, insisted that what had happened to Mr. Paul was wrong and that he didn't trust law enforcement.
And did he make any distinction about which agencies, or did he talk about all law enforcement?
It was specifically the FBI and the Department of Public Safety.
And did he say why he didn't trust them?
He said that he compared what had happened to Nate Paul to General Paxton's own personal situation involving the Department of Public Safety and the State Securities Board and the FBI.
Well, were you aware of who provided his security?
Yes, sir.
And who was that?
The Department of Public Safety.
Did he indicate in his comments what his level of feeling or trust or distrust about them was?
Not to me.
All right. Now, how long did he, when you expressed what his initial opinions were, did he go any further, or how did the conversation proceed?
He asked me if he could obtain a copy of the DPS file.
What did you do?
I said that it was possible for him to receive a copy of the file.
And I believe you said this was around May 15th, did you not?
Yes, sir.
Did you provide him the file?
Yes, I did.
Did it have everything in it?
Yes, sir.
Did you take anything out of it?
No, sir.
Can you tell us whether or not in that file you had, there was any brief from the FBI weighing in as to their materials in the file and their position as to whether it ought to be released?
Yes, the FBI had submitted a brief in response to the DPS request.
What was the process or procedure within your department if you have a request for open records, people want to get some portion of it from another agency? What was your policy as to let the other agency weigh in?
The Public Information Act requires state agencies to notify the third party whose information may be at stake that they have a right to submit a letter ruling or a letter brief to the Office of the Attorney General for consideration.
So in these circumstances, would it be normal or unusual for y'all to have notified the FBI there was this request, that the request was to an agency whose files included FBI materials? Would it have been usual or unusual for them to let them know so that they could respond if they wanted to?
So in this situation involving the DPS request, the Department of Public Safety did notify the FBI that its information may be at stake in this request for a ruling. And the FBI responded by submitting a letter brief to the Office of the Attorney General under the ordinary principles of the statute.
Were you aware through these materials and looking through the file that there was an ongoing federal investigation of Mr. Paul at that time?
Yes, it was clear.
Did you take a position with the Attorney General that there was an ongoing, at least federal, I'm not including right now state because I have no knowledge one way or the other, but that there was at least a federal ongoing investigation of Mr. Paul that release of these documents would interfere with?
Objection, leading.
Sustained.
Did you inform him one way or the other about, did you have discussions with him concerning the topic of an ongoing federal investigation?
Yes.
And what did you tell him and what was said?
It's my recollection that there were discussions about the substance of the brief that the FBI had submitted, the quality of the arguments that they had raised and made.
And did this brief provide details of the ongoing federal investigation?
Objection, that will solicit hearsay, Your Honor.
No, I'm not asking for communication. I'm just asking whether or not it contained details about it.
May I be heard on that?
Yes.
Mr. President, so Mr. Hardin is asking the witness about the contents of some other document that is not currently in evidence, pretty much right down the fairway of hearsay.
I'm not asking
I'm
for
going to sustain, rephrase your question.
Well, I'm not asking you for specifics of what it said. I am only saying, were there documents and information in this file that were used as the basis of a conversation with the Attorney General concerning the presence of an ongoing federal investigation of Mr. Paul?
Yes, sir.
All right. Now, when you gave the file to him, how did that happen? You go to his office? What did you do?
I believe I delivered the file to Andrew Wicker, who was General Paxton's aide at the time.
And did you later confirm that Mr. Wicker gave it to the Attorney General?
Yes.
And how long was it? Will be some intervening events I'll ask you. Well, how long was it after that event that you retrieved your file from the Attorney General?
Well, as I mentioned, when the the Office of the Attorney General has to make a ruling, it's on the clock. So we have a timeline. I was notified by Justin Gordon, the chief of the Open Records Division, that we needed to make a decision because the clock was coming up. It was approximately 7 to 10 days before that when I delivered the file to Andrew Wicker, and Mr. Gordon had emailed me asking for a status update.
And so then how long after, back to the original question, was it from the time you gave it to the Attorney General to you? Let me ask you this, was it ultimately returned to you?
Yes, it was returned to me.
And when was it returned, approximately when was it returned to you?
I believe it was May 28th or May 29th.
All right. And in the meantime, were you part of any later conversations after the one you just relayed, in which you expressed your opinion, the Attorney General expressed his? Well, let me back up. In that second meeting, counting the first meeting being him asking you to look at the file, okay? The second meeting would be the one we just discussed. In that second meeting, did the Attorney General give you any indication as to what he wanted you to do?
Well, he wanted us to find a way to release the information.
And after you expressed yourself, Mr. Bangert expressed himself, the Attorney General expressed himself, in that second meeting, was there a conclusion as to what was going to happen?
No, sir, not that I recall.
All right, how did the meeting end up?
We were essentially at an impasse on our recommendation not to release the information and the Attorney General's decision to release it in some form. We told the Attorney General that we would review our options and follow up with him to see if there's anything else we can look at.
What was his position as to whether or not he wanted or thought the law enforcement exception should apply?
He didn't necessarily take a position that I recall other than something happened to Mr. Paul, it was wrong, this shouldn't be allowed for the FBI and the DPS to get away with.
All right. Now, after that, when was the next time you had any contact with the Attorney General on this matter?
Again, it probably was a matter of days after that, just in light of the timeline and the deadline. We followed up and let General Paxton know that we looked at it again. We didn't think that we could reach an alternative conclusion.
And who was the we in that part?
Ryan Bangert and myself.
And how did you let the Attorney General know?
We met in his office.
And do you recall when this third meeting was?
I believe it was toward the end of May.
And
Counselor, not to interrupt, we're a little past our mid-afternoon break. Is this a good spot, or do you want to go?
This is
You're
fine
here?
Sure.
Okay. We'll stand in recess until 3:30.
And we've been listening to testimony from Ryan Vassar, who rose through some ranks at the AG's office after starting to work there. Let's see, he says several years ago, it was 2015 when he joined the AG's office, and 2019 when he was promoted, and he was heavily involved, as they are discussing now, Ashley, this open records request, this effort by Nate Paul to get sensitive law enforcement information involving a law enforcement investigation into him. He was the target of that investigation. And so, according to a testimony from Vassar, Ken Paxton was pushing for the Attorney General's office to find a way to get that information to Nate Paul. In fact, Vassar even said that the Paxton told his staff to literally, quote, find a way. And Vassar says that he responded that it would upset decades of precedent involving the law enforcement privilege, meaning the law enforcement privilege often grants, or generally grants, agencies from having to release information during an ongoing investigation.
Well, and not only that, he talked about the problems that this would have, that this could potentially set if you release that type. For the Attorney General's office, the AG's office always sides with law enforcement.
I said, almost 100% of the time. I can literally count with me a requester for information and not withheld it. And actually, I made this point earlier, but I, if I may say so myself, do think it bears repeating. And that is when you look at high-profile situations like the Uvalde school shooting last year, where there was enormous public effort to get investigative information, those parents, the news media suing
From across the country.
And Ken Paxton and his Attorney General's office holding firm that because DPS and the Uvalde County District Attorney did not want the records released, citing an ongoing investigation, Paxton and his AG's office said no. So then when you juxtapose that with one man wanting information about an ongoing investigation into him, it is certainly noticeable.
It undoubtedly into him for alleged wrongdoing. And let's talk about, because the into him, the man, Nate Paul, is indicted.
Exactly. The investigation did result in a number of criminal charges against him. It's a fraud case here in the Western District of Texas, the Federal District, the Western District of Texas, essentially alleging that Nate Paul either overstated his wealth or understated his financial liabilities in order to get millions of dollars in loans, Ashley. So from a law enforcement perspective, it was a fruitful investigation into his alleged activities.
And so this testimony, what we're talking about here, these particular things, these are related to benefit.
Exactly. Ashley, I think another thing that was striking to me, and I know we were talking about it as it was happening, and that is for the first time, and we've talked about emotion being part of, infused into the testimony of some of these folks.
Generally frustration.
Yeah, generally frustration. But Vassar really showed us how much Ken Paxton's public statements about the whistleblowers, calling them rogue employees, how much that hurt him.
Yeah, he was actually wiping tears from his eyes. They paused for a moment so someone could give him, a Kleenex. And he said, quote, that it was contrary to the years I dedicated my life to the state. This is a young man who, at the time when this is all happening, has 4 very young children, aging from 6 months old to 4 years old, who has a wife at home who is staying home with the kids, a stay-at-home mom, because 4 kids, I've got one, I can tell you, 4 with those age range. But yet, this is someone who believed, as we've said, a conservative who is fighting the good fight and doing the work, carrying out the conservative principles for, his ideological beliefs. And so, for someone of that stature, who needs his job, needs the check, needs the employment, to feel like wrongdoing was happening to the point where they needed to tell someone, and then to be fired, and then to be publicly painted. And he said it was about 6 months before he was hired again, before he could get another job. That is emotional. You can understand why someone would be emotional.
It is very much noteworthy, though, that when this proposed $3.3 million settlement first surfaced and first came up in February, when those whistleblowers reached the tentative settlement agreement with Ken Paxton, again, the backdrop for this whole impeachment process.
The settlement.
But under the terms of that proposed settlement agreement, Ken Paxton agreed to apologize for calling those whistleblowers rogue employees, and Ashley removed from the OAG's website a statement saying such as well.
And that's actually that's actually related to some of the other articles. And so Article 6 is about the termination of the whistleblowers, and then also Article 7, this all deals with them, and Article 8 deals with the settlement agreement and the agreement in and of itself, saying that by entering into that agreement, Ken Paxton, deprived voters, is the words that the House managers used, from getting to know about what really happened with him. And from, you stopped the trial process, so then you're stopping voters from learning about what all has happened and what has truly transpired.
And if you are just coming into this story, this historic impeachment process, lawmakers have said, the House managers said, but for Ken Paxton bringing us a $3.3 million settlement proposal to be funded by taxpayers, we would have never brought forward these impeachment articles. But after he did that, they felt as though they had to fully and broadly understand the alleged conduct of Ken Paxton that led to all of this happening.
And a point that I think when we're talking about that worth noting is, the lawsuit is with the Attorney General's Office of Texas. It is not with Ken Paxton, which is the law. It has to be against the office and not the person. And so the argument from Ken Paxton's attorneys and other staff in the AG's office is, well, but you're not asking Ken Paxton for the money. You sued the office. You were terminated from the office. And so the office is who has to pay you out. Certainly worth noting that with all of this, that payment has not been given to those.
The payment has not been given. And the truth is, barring some sort of special session happening, it likely won't happen until the 2025 legislative session.
There may be a world.
There may be a world
where Governor Greg Abbott, we know we're coming back for a third special session to deal with school finance and the school choice, school voucher fight. He's made that clear that's happening because, again, we had that record budget surplus, and there is money that was earmarked in the budget that has passed and is in effect it has nowhere to go.
Yeah.
There's billions of dollars that was set aside that has nowhere to go. So maybe there's a world where Governor Greg Abbott adds it to the call.
Right. And I honestly don't remember if there was a time frame that was established in the proposed settlement.
Well, and the settlement still has to be approved.
I knew that at one time.
Many things have happened between February and today.
Right. I knew it at one time.
Yeah. Well, and it still was subject to a judge's approval, was it not? Settlements have to be approved.
Exactly.
So that was still, a factor in all of this.
But the first step was certainly the lawmakers had to approve the settlement. Yes, exactly.
So we're hearing from Vassar on the stand. Tony, anything that really stood out to you before he took the stand? We had our second day of testimony hearing from Ryan Bangert, who was the second in charge of the AG's office. What really stood out to you about his testimony and what he had to say?
Well, I also want to say, too, Ashley, and if I could, ring up Rusty Hardin or Dick DeGuerin right now, one of the questions I'd want to ask them is, do you intend to call every whistleblower? Do you believe, I guess they don't, that Jeff Mateer sort of made the case on behalf of all of them? But keep in mind, there were 8 of them who originally signed a letter saying that they were going to the FBI to report Ken Paxton. 4 of them, again, as we know, subsequently sued. But I wonder if the intent of the House management is to call all of them or some of them, if this is the last one, 3 of 8, or if they are going to continue doing that.
So let's remember when we're thinking about that, because we have a time limit, unlike a criminal trial, unlike, what I think we're used to, and frankly, what the attorneys are used to. The clock is ticking. Each side only gets 24 hours to have witness testimony and to cross-examine. And so it's taking, it's 24 total for you to have witnesses and cross. So you've got to keep your eye on the clock here. Because you have to think about that, and we have a potential witness list of 100 people.
Right.
But I don't know, Tony. I would see where perhaps you would call all 8, because these are largely These are the people who largely, they are why we are here.
That is absolutely true. And I will also say the feedback that I've been getting, people texting me who are attorneys, who do have a lot of courtroom, I use that in air quotes in this situation, courtroom experience. I mean, they are saying things like, we have never seen a witness this credible. These are attorneys. They have the facts. They know this game. They know the tricks to try to get them to stumble or to get them off course. And when you look at Bangert, he was very clinical, I think, in his responses to the questions, sometimes very tense questioning that he was facing.
I think I was most, what stood out to me was how sharp he was. Nothing scooted past him from him even correcting one of the assistant defense attorneys, Anthony Oso, even him correcting him on the question that he was asking him. He was so sharp, just on top of it.
Totally. Yeah, I mean, it certainly seemed that way in terms of him, like catching any sort of mistake or misspeak or anything like that.
And even his content of it, he was asking him yes or no questions and being very adamant. I cannot answer that as a yes or no. That has legal implications. Almost, some might say almost schooling him on a few things legally about what he can and can't say and what he was willing and not willing to answer to and what he was not willing to say.
I'm curious about your thoughts about how you think it's going with the lieutenant governor.
I think that the lieutenant governor is doing the best that he can. I think, where there's no secret, the rules allowed and named Lieutenant Governor Dan Patrick to be the presiding officer. He could have delegated that to a judge, but again, this is a historic moment.
Right.
This is a historic moment that will go down in the history books, and so I can understand wanting to preside in your chamber with your staff, familiar, not wanting to delegate that duty. You do see him if you're watching. You will see Judge Lannemeyer coming over, advising him. But he's also, I think, getting a little more comfortable right now in making decisions. You remember during the first day of the trial ended abruptly, as he was supposed to be ruling on a motion, and he said, well, I'm going to sleep on it.
I think it's also interesting, too, that there was this sort of question, at least, about whether or not Dan Patrick, the degree to which he would take this trial. In other words, was it just going to be a big show and give them cover to ultimately acquit Ken Paxton, or was it going to be a fair, thorough trial? And as best we can tell right now, it appears as though the lieutenant governor is treating this very seriously. That's not to say that they ultimately will not acquit Ken Paxton, but in terms of the thoroughness and the seriousness that the lieutenant governor seems to be approaching this, I do think that's in place.
Well, and his rulings, I'm sure that we're not this meticulous, but if you were ticking off how many motions he is sustaining and objecting for each side, it seems like it's about just observing from the outside, a casual observation. It's pretty even. He doesn't appear to be playing favorites here with one side over the other.
I think that's true, but it will continue to be interesting to see how he manages this, how he approaches all of this. And, again, the House impeachment prosecution, the managers, are using their window to clearly bring in these whistleblowers, these attorneys, working to establish their credibility, their conservative bona fides, their work as attorneys, both at the AG's office and other organizations.
Yeah, and as we mentioned that, Patrick not playing favorites, he did deliver, I would say, a heavy blow. I think you call it a heavy blow too to the prosecution when he made the ruling that Ken Paxton was not going to have to take the stand. This was one of the questions. This was one of the motions that was presented solely to him, not to the full body, because it obviously would not have resulted in a dismissal. But, him saying, just constitutionally based, the House Board of Managers has been carrying this out like a criminal trial. And in a criminal trial, you, the accused, are not required to take the stand. And so he made the decision that Ken Paxton could not be compelled by the House managers to get on the stand.
And as we have said before, Ken Paxton remains under a federal investigation. He could be charged federally for this alleged conduct. We haven't talked about this. You can bet your bottom dollar the federal government is watching this trial right now very closely. Of course, the witnesses, the whistleblowers have said that they have been interviewed by the federal investigators. But yes, it is almost a certainty that they are watching this proceeding right now, trying to figure out if there are additional pieces of information or pieces of evidence that will help their case.
We're watching as the senators are starting to walk back onto the floor from this break, and that raises another point, Tony, about the witnesses, and to your point of how knowledgeable they are. We have seasoned attorneys, and while this should not be political, while politics and partisanship should be put to the side, we know that this is still politics.
Well, and the lieutenant governor said as much.
Yes,
I mean, yes, they constitutionally they should put their party affiliation aside, but this group of conservative Republican attorneys that we've seen on the stand thus far are clearly speaking to those Republican lawmakers who are having to decide if they are going to side with Democrats and vote to convict, or if they are going to vote to acquit. It's a very difficult time, sort of the inter-party fighting within the Texas GOP, and we're seeing that. I mean, we're seeing that with regard to some of the far right going after some of these whistleblowers and after some of these witnesses.
Well, and not just and to that very point, State Senator Drew Springer actually released a letter today on Twitter saying basically to his constituents who have been calling him and writing him and asking him to take a side or to influence. He wrote them and he said, quote, "Please understand that in this unique circumstance, I cannot comment or engage in any discussion as I am in the position of a juror. I am also under a judicial gag order that prohibits discussing the matter, and his staff is held to the same standard." Basically saying he's received so many calls and emails about this trial, and while he appreciates hearing from his constituents, in this moment, he is a juror, and he's saying that, he says, quote, "As your senator, I hold my constitutional duty as a member of the Court of Impeachment in the highest regard and will continue to honor my oath." And this is, I think, it speaks to what's happening on the outside with the
Right.
PACs.
They're getting lobbied, essentially. Yeah. And we've seen similar statements from other senators as well, other Republican senators, essentially saying, "I'm a juror, love you, constituent.
Help you with anything
else, but not in a position to help you on this one."
And I think this is that response is what the people of Texas, the majority of the people of Texas, would want to see. I think anyone who has had to serve on a jury has to walk in with a clean slate,
right?
And to at least hear from our senators that they have taken an oath and they're taking that oath very seriously. That oath that they took on Sam Houston's Bible.
Yep.
To listen to this and to be fair and to truly serve as a juror.
So we can expect at this point that Ryan Vassar will remain on the stand the rest of the day. If the two previous witnesses have been any indication of that, we will at least close the day with him. But keep in mind that the previous two whistleblowers were on the stand for hours.
Yeah, over the span
Many
of
hours.
2 days each.
Yeah.
Over the span of 2 days each, we heard from them. And Lieutenant Governor Dan Patrick saying that they'll probably go to 6:30, 7 tonight. So lucky us.
Yeah.
Lucky you who's watching it. And I do expect
We're
that
accepting
especially-
Starbucks deliveries or coffee deliveries here at 3201 Stack.
Absolutely, absolutely. But yeah, I think that is something that especially with the cross, for me, I think it will be interesting to see who will cross-examine, because the rules state only one person from either side can do the cross. So it's not a situation where Anthony Osso can start and Tony Busby can step in. Whoever starts has to finish with that witness. And so that, I think, is really interesting to see who they are going to let cross Vassar, particularly since he did show a little bit of emotion that was different.
The most emotion.
Different,
fair,
right?
Yes, fair enough.
Because
yes.
Mateer was visibly frustrated.
Right.
And annoyed by what was happening. It looks like they are back and starting again, so let's listen in.
Now, Mr. Vassar, I'm just curious, what size is this file? You know, it just occurred to me, everybody's been talking about this file that was the essentially open records request for Nate Paul and all. We've talked about what was in there in terms of descriptions, but what size file are we talking about, just visually?
It was a manila envelope that was maybe a 1/4 inch or less in thickness.
All right, and was it actually contained in a manila envelope?
Yes.
So like have a seal, not a seal, but like a little closing up at the top?
A label.
All right. Did you keep it sealed, or is it just in a manila envelope?
It's just in an envelope, not with the flap on top, but just a folding manila envelope.
I got you. All right. Now, at this time, we are, I think you said somewhere around May 28th, is that right, when the file you're estimating was brought back to you?
Yes, sir.
And that would have meant when you said that you believed you gave it to him around when in May?
The middle of May.
So about, the math would say like 13, 14 days. But you give me what your figure is.
I would say May 23rd.
May 23rd, when you gave it to him?
Correct.
All right.
And then when it was returned on the 28th.
I got you. So you didn't have it for about 5 days.
7 to 10 days was what I recall. I apologize for the math.
All right. So at any rate, that period of time, it was out of your possession to be in the possession of the Attorney General, correct?
Yes, sir.
All right. Now, when you got it back, so let's say toward the end of May, what was the next event or conversation you had with anybody, the Attorney General, concerning Mr. Paul?
The last meeting that we had regarding the Department of Public Safety file was that we did not recommend changing our conclusion to protect the information, but that there might be an alternative solution to take in issuing a ruling.
Why did you come up with an alternative?
General Paxton had asked us to find a way to release the information.
So who came up with a possible alternative?
Justin Gordon, who's the chief of the Open Records Division, had...
And what was that partial, that compromised position?
It was basically taking a position of no position. So we were not making a ruling saying to withhold the information, and we were not making a ruling to release the information.
Had you ever participated in that kind of position before?
No, sir.
Were you aware of it having been done before?
Not until Mr. Gordon suggested it.
Now, I'm not suggesting to you that never had it before happened in my question in the AG's office. I really am just simply asking, were you familiar with it ever having happened before?
No, not in the open records context.
All right. Now, well, what would be the implications of taking a position of no position? Would that be of any advantage to anyone as opposed to declining to release it? Let's do this. Under no position, would there have been 3 possibilities then that you would be treating that request? Here's what I mean. Just a flat out, we're not going to release the information because of law enforcement. That would be one, would it not?
Yes.
Another would be release the information, give it to them as they request. That'd be one, right?
Yes.
And then in the middle of that would be take no position, correct?
That's right.
If you take no position, does that have any different consequences than refusing to turn it over?
Objection, Mr. President, calls for speculation on the witness's part.
Sustained.
All I'm really asking you, I'm going to try to ask you in a way that's acceptable. I'm trying to determine what is this, why do no position then as opposed to just you can't have it? What's the significance of no position?
General Paxton didn't want for it to appear that his office was aiding the Department of Public Safety or the FBI. And so by taking a position of no position, it was semantics, I suppose.
Well, what is your testimony as to whether if you say no position in terms of what you're communicating to people outside the agency as to the level of resistance you have to resisting?
Objection, Mr. President, calls for speculation on the witness's part.
Sustained.
Now, at any rate, was that the decision that was made?
Yes.
No position.
We were directed to take a position of no position.
And in these conversations and all with the Attorney General,
Yes.
had you expressed your position in being opposed to that?
Yes.
Had Mr. Bangert expressed his position of being opposed?
Yes.
Was there anybody else involved in talking about it with the Attorney General?
Not with the exception of Mr. Gordon, who had attended one of the series of meetings.
All right. And was Mr. Gordon have the same position as y'all did, even though he's the one who came up with no position?
Yes. My recollection is his initial review was very flattering of the quality and the content in the FBI's letter ruling.
Now, after that, did there become a separate issue from reviewing the file? At some time, did Mr. Paxton's lawyer's position, Mr. Paul's lawyer's position become, well, we want the unredacted FBI brief?
Objection, leading and compound.
Well, I'll be glad to rephrase that. Let me give it if that's okay.
I'll sustain it and rephrase.
Thank you very much. So let's go back now. And we, in that file, was there a brief that had been prepared by the FBI saying why the documents should not be released to Mr. Paul?
Objection, Mr. President, asked and answered.
Overruled.
Was there?
Yes, there was.
And you got to speak in the microphone. Is your microphone on?
Yes.
Okay.
Yes, there was.
That's all right. And you're going to find you get tighter and tighter as the day goes on. You got to stay up there. I speak from experience, okay? In this particular case, did the FBI brief, what type of information was in the FBI brief if it was not redacted?
Objection, Mr. President, this calls for hearsay and the contents of a document that is not in evidence.
There's no hearsay at all here. This is simply asking what documents were. These are not communications. And this is nothing.
Hold on one second. Overruled.
What type of documents were in there?
The FBI's
Or by the, I say in there, referred to in the FBI brief.
Right. The FBI's brief identified emails, text messages, strategic planning, staging locations for the raid in August of 2019. They identified the task force members. The brief identified a under seal probable cause affidavit that said it was filed under seal, and the FBI brief indicated that that seal had not been lifted.
And so, including all these, when we talk about that affidavit sealed, it was actually under seal at that time in a federal court, wasn't it?
That's what the FBI brief
So
said.
the federal judge has ordered it sealed. It had not been unsealed. But if the FBI brief unredacted was released to the object of the investigation, that person would have all kinds of information that a federal judge had sealed, correct?
Objection, Mr. President, leading.
I'm asking just, is that correct?
Sustain, rephrase.
What type of information, without going into the details of the FBI, let me back up this way. In the FBI brief, did they, without saying right now what they were saying, did they lay out sources, names of witnesses, background and history of the investigation, personal data of investigating officers, and personal data on individuals? Was that included in the FBI brief as they argued against this disclosure?
Objection, Mr. President. Once again, this is not, the witness's testimony is not the best evidence of the content of this material.
Well,
it has not been entered into evidence, and it remains hearsay.
Your Honor, surely we can't keep that information from this record. I'm asking you simply of the types of information was in there.
We'll overrule. You can ask for the types of information.
Thank you.
Limited to that.
So, I believe my question was, in the FBI brief, did they, without saying right now what they were saying, did they lay out sources, names of witnesses, background, history of the investigation, personal data of investigating officers, and personal data on individuals? Was that included in the FBI brief as they argued against this disclosure?
Yes, that was all the content of the probable cause affidavit that I recall.
So, what was your understanding as to whether or not lawyers for Mr. Paul were asking for things to be disclosed by the Attorney General's office that a federal judge had refused to disclose and sealed?
Objection, Mr. President, leading.
I can ask it another way. Were you aware that a federal judge had placed these documents under seal?
Yes, sir. Based on the content of the FBI brief that indicated that the records were sealed and that the probable cause affidavit was identified as sealed.
So essentially, was the Attorney General of the state of Texas seeking to reveal to a person under a federal investigation the basis of the evidence so far that the government had against him?
Objection, leading.
Sustain, can you rephrase that?
Sure. Was there a clear clash here between what the judicial system had decided that it should be sealed versus a man under investigation seeking the sealed information?
Yes, that was my opinion.
And was the information he was seeking particularly harmful and dangerous to other people, if disclosed?
I believe so, to the extent it revealed the law enforcement information within the probable cause affidavit, the investigators that were involved, and other government officials that participated in the decision.
All right, so how did it proceed now about whether or not, by the way, by this time, can you give us a time frame where all of a sudden they're seeking the FBI brief?
I believe the request was submitted May 24th of 2020. So it was in the middle of our conversations about the DPS file itself.
All right. And did they, when they were seeking it, how long do you think it was before y'all provided an answer?
I think the answer was due sometime in July. I want to say that July 28th.
Of their open records request for the FBI brief, is that what you mean?
Correct.
Okay.
So if I can lay it out,
yeah, please,
on a calendar.
please.
The DPS file was due June 2nd. The request by Nate Paul's lawyers to the AG's 4th. I believe the deadline to issue that ruling was July 28th, just based on the 45-day or 55-day time period.
Mr. Vassar, if we do this in a time frame, what is your testimony as to whether or not the request for the FBI brief by itself came before the no decision on the release of the DPS file? Did it become before or after?
It came before, because the DPS decision was not issued until June 2nd.
All right. When the June 2nd position was issued, I believe that was what you said was the no decision. Is that right?
Correct.
All right. Now, anytime after y'all said no decision, was there any attempt anymore by people on that Mr. Paul's position, excuse me, was there any attempt any longer to get access to the whole file?
No, not to my knowledge. So just generically, under the Open Records Act, when the Office of the Attorney General makes a ruling, the parties have the right to appeal that ruling to the district court. I'm not aware if that happened.
That's another way. So to your knowledge, are you familiar whether or not after y'all said no to the DPS file on June 2nd, was there any attempt by Mr. Paul's lawyers to appeal that to a district court as they were entitled to?
I'm not advised of that.
And instead, did they move to be trying to get an unredacted version of the FBI brief?
It's the timelines are suspicious.
And they're suspicious for what reason?
Sorry, Mr. President, I'm going to object to the witness's speculation and unresponsive statement and ask Your Honor to strike it from the record.
Yeah, we'll sustain that and strike that from the record. You can ask any other question.
When you issued no opinion on June 2nd, was there in that no opinion a redacted version of the FBI brief?
No, sir.
All right. As of June 2nd, did they had access to the FBI brief with the probable cause affidavit setting out the basis for the search and arrest?
Objection.
Just give me just a second. I'm sorry.
Please.
Strike the word arrest. There wasn't an arrest. I didn't mean that. Go ahead.
Objection, Mr. President. Calls for speculation. I understand the question to be asking for what Nate Paul's lawyers did or didn't have, unless I misunderstood Mr. Hardin.
Objection sustained.
Would it change if I said he misunderstood me?
Give it a try.
All right, no problem. All right, now let's do this. What was the decision? Did you have any conversations with the Attorney General on the issue of releasing to Mr. Paul the FBI brief?
Yes.
How did those conversations happen? When? Where?
They coincided with our conversations about the DPS file, just given that the timelines overlapped.
All right, so can you estimate the time frame when you talked to the AG about whether to release the FBI brief?
I believe it was the last week of May.
And when you did so, what did you do? I mean, what was the decision? Can you tell me what the Attorney General said?
I had notified General Paxton that the office had received a public information request related to the DPS file, and it was a request for the unredacted FBI brief that the FBI had submitted.
And what was his response?
He asked to see a copy of the two briefs, the redacted version and the unredacted version.
Did you give them to him?
Yes.
What happened next?
We met maybe the next day, and he showed me the two versions that I had sent to him, and he had highlighted and circled and marked up some of the documents. And he stated to me that he didn't see anything in here that should be withheld.
Attorney General of the state of Texas, are you saying, actually went over the affidavit and the brief, all the information that was referred to in the brief, and made circles himself on it?
He marked up the copies of the letter brief that the FBI had submitted to the Office of the Attorney General.
And the Attorney General decided, what had been your advice as to whether it should be released?
Well, the initial step in that process would have been to notify the FBI that the office had received a request for its information.
Did you do that?
Yes, I did not personally, but
Was it done?
it was, yes, sir, it was done.
And what was the status? Were you waiting for their response?
Yes.
What was did the Attorney General have a position about that?
On the response,
Yes.
so it was my understanding that there was a delay in either connecting with the FBI or the correct person to make a decision on whether to respond and how to respond. After a follow-up attempt to contact their office, I don't know the content of that conversation, but I know we made a couple of attempts to contact them.
And then when you were unsuccessful in figuring out who in the FBI to talk to, what happened then?
After mentioning all of these sequences of events to General Paxton, he directed us to let the brief go out.
And he had earlier told you he didn't see anything that was a problem releasing?
That's right.
Do you know anything about the criminal law or practice history that Attorney General might have been particularly informed about to make those kind of decisions?
Objection, Mr. President, calls for speculation.
No, let me rephrase it to make sure it's understood.
Sustained.
Do you know of anything that you've ever witnessed or observed in terms of knowledge, background, or history of the Attorney General to be making a decision about what law enforcement information should and should not be released?
No, sir.
All right. Now, when you released, are you saying that the Attorney General's office released an FBI brief, unredacted, to the subject of a federal investigation, in spite of it having pointed out that the information in there currently was under seal with the federal judge?
Objection, Mr. President, leading.
I don't think that's leading. I can.
Stating. Sustained.
Pardon me?
Sustained.
All right.
Rephrase.
Tell us exactly what the consequences and what he did when he ordered that brief to be released to the subject of a federal investigation.
So the decision to release the information was done under the Public Information Act in order to reach a decision that the office was required to make in response to a request for information. Based on what I recall, the absence of the third party responding or responding in time or informing the office that it didn't intend to fight the release resulted in a release under the Act.
Well, would you have released it even if you were making the decision? Let me put it this way. You, as a courtesy, tell fellow law enforcement agencies this is under consideration, correct?
It's a required notice under the Public Information Act.
In your processes, are you allowed and able to review law enforcement information from another agency? And even if you don't hear from that agency one way or the other, do you have the authority to declare the law enforcement exception to apply and hold it back even if you don't hear from the other agency?
There are situations in the open records context when the Open Records Division may raise exceptions based on the information that it reviews that may not have been raised by the parties.
In this particular case, what was your position, even when you had not heard from the FBI yet? What was your position as to whether this FBI brief, unredacted, should be released to the subject of the investigation?
I believe that it should have been withheld just based on the content of the document.
And did you argue that position?
Yes.
Did you argue that position even when you had not heard yet from the FBI?
Yes.
And once that information is released, is it released under any conditions, or can the recipient share it with anybody he wants to?
It's not released under any conditions.
So when you release law enforcement information through a Freedom of Information Act or public records request, once that information is out, if anybody wants to find out, what would be the possibility if anybody with larceny in their heart wants to know addresses, names, all kinds of personal information about law enforcement or witnesses, would they potentially have access to it if the possessor wants to give it to them?
Objection, Mr. President. This is leading and calls for speculation on Mr. Vassar's part.
Sustained.
Mr. Vassar, are you aware that in September of 2020, a quote special in the file that your agency released?
Objection, Mr. President.
Are you aware of that?
I'm sorry. Objection, Mr. President.
That is why this is relevant.
Don't talk to each
one
other.
second.
What is your objection?
Objection. Assumes facts not established in evidence in this trial, Your Honor.
Your Honor, I swear to you under my oath as a lawyer, you're going to have that evidence presented. Now,
I don't have it now.
Pardon me?
We don't have it now.
I know that, but it's coming. My point being is I'm only asking him if he was aware the event happened. When he talks about evidence not be before the court as yet, I'm seeking to find out if he's aware how this information was used. He can say he's not aware, and that ends the inquiry. But if he says he does, it points out the danger of what exactly happened here in this case, which is at the heart of the major impeachment contentions that we have.
Mr. President, may I be heard?
Yes.
I have great esteem for my colleague. However, I promise it's coming is not a proper response to that objection.
Sustained.
Only this question. Was the type of information I talked to you about available then to the recipient once you released the FBI brief?
Mr. President, same objection, same horse, different question.
Still a legitimate question. The question was that available to the recipient? That's all. I haven't asked about anybody else you haven't heard information about. I'm talking about the person in this case, Nate Paul.
In this case, Counselor, I'll overrule.
Was it?
The information that would have been in the FBI brief is what would have been disclosed to the requester.
Thank you. Now, can I move on to was that the last contact? To your knowledge, did the representatives of Nate Paul make any more attempt after you released the FBI brief? Was there any more attempt to get the information from the DPS?
Not to my knowledge.
So what is your testimony as to whether or not, after you issued no opinion, but then released the FBI brief, was there any more attempt to try to get to a fuller file of DPS?
Not to my knowledge.
Thank you. And was there any lawsuit, to your knowledge, filed in state court to try to get it?
No, sir.
What did that indicate to you?
They may have gotten the information.
From some other way?
Yes, sir.
All right. Now, if we can, when's the next thing you had to do with Mr. Nate Paul?
Well, unknown to me at the time, Ryan Banger contacted me on July 31st, which I think was a Friday, in the evening, and asked me about a foreclosure opinion.
Did you? And how did that come about? That was, but you remember what day of the week that was?
It was a Friday evening.
All right. And Mr. Vassar, what did you understand that your responsibilities and mission were?
So Mr. Banger contacted me and told me that we needed to look into foreclosure sales.
And did you understand, who did you understand this was a request from, that you were asked to do this?
From General Paxton.
Do you recall where you were when you got the information?
I was at home.
And what did you do as a result?
I responded to Mr. Banger over the phone and told him that I would look into it. I would give him a first draft as soon as I could.
Now, what time of day was it? Was it, first of all, what day of the week was it?
Friday.
And what time was it on Friday night that Mr. Banger called you?
Between 5 and 7. I mean, it was.
And at that time, did you understand in response to the initial call there was any urgency one way or the other?
Yes, it was
And when the urgency, when were you supposed to try to have this opinion?
as soon as possible.
What did that mean to you? No, it's okay. Go ahead.
I told Ryan that I would get him a draft sometime that evening, if not first thing in the morning.
All right, did you do that?
Yes.
And then what did you do the rest of the morning in connection with it?
Ryan and I spoke about the draft. He agreed with the initial conclusion, which decided that foreclosure sales should be allowed to proceed under the governor's executive order at the time.
All right, and were the two of you in agreement with that?
Yes.
About what time of day did y'all get a document that you thought was sufficient to send over to the Attorney General as a draft?
It was probably 11 to 12 on Saturday, that next day.
What's the next thing you did in connection with it?
Ryan called me not long after that, probably 30 to 45 minutes after he had sent it to General Paxton.
Were you aware as a result of that phone call whether he had talked to the Attorney General?
Yes.
And as a result, what did you understand your new mission was?
I understood that General Paxton said that we got the wrong answer.
All right. So the right answer had been what, in your view?
Well, based on the office's position on numerous COVID-related matters, we had erred on the side of opening Texas, not closing Texas or prohibiting people from gathering. We had issued a number of opinions relating to houses of worship, election issues, and schools, all of them encouraging opening, not closing it. So the initial conclusion was based on my understanding of the office's position throughout the summer.
And did you make a legal determination that went in line with what you believe the office policy was?
Yes.
And then what happened when you were told you had the wrong answer? What did you do?
I laughed.
Why did you laugh?
I just because I found out that I had gotten the wrong answer when I believed I had reached the right answer just based on the office's position throughout the summer.
All right. So then what did y'all do?
I told Ryan that I would take a look at reaching a different conclusion. I think he volunteered to do that and made modifications to the draft that I had sent him.
Now, you two guys are deputy chiefs of the whole office, right?
Ryan at the time was deputy first assistant, and I was deputy for legal counsel. Yes, sir.
Well, you were pretty high up in the food chain, were you not?
Yes, sir.
How often do you two write opinions?
Rarely.
Do you have any idea why the two of y'all were doing it rather than very capable lawyers underneath you in the litigation section?
I think it was a priority issue that General Paxton wanted someone to get it done as quickly as possible.
All right, so who did the main drafting this second time?
It was essentially the same shell of the first draft, and Ryan Banger revised the conclusion to conclude that foreclosure sales should not proceed.
Were you aware of at that time any contacts that Mr. Banger and the Attorney General were having in drafting the opinion?
I knew that Ryan Banger was speaking with General Paxton.
And were you getting any kind of progress request or not? Were you aware of how often they were speaking one way or the other?
No.
All right. And then was there any challenge to rewrite it?
Well, I mean, we had to go back and adjust the analysis to the extent we could based on the position that we had taken initially.
All right. Now, once you completed it, about what time in the morning on Sunday did you complete it?
I spoke with Ryan throughout the day on Saturday after we were exchanging drafts and trying to reach an opposite conclusion. It's my understanding that he finished around midnight on Saturday evening.
But was he passing on to you, and y'all discussing at that time any involvement in the Attorney General in the editing process?
I was not involved in any conversations directly.
That was going to be my next question. So during that entire evening that night, is it correct to say you were not dealing with the Attorney General, only Ryan was?
That's right.
Okay. Now, once it was produced, at any time during that process, did you have any idea whether or not this was something that would or would not benefit Nate Paul?
No, sir.
Did you later change your opinion or your sense of awareness?
Objection, Mr. President. This calls for speculation.
I'm only asking about his mind state. I'm not asking anybody.
Overruled.
Thank you. Go ahead.
Yes, sir. I believe Monday, I think it was Tuesday.
And what changed your mind Tuesday?
Well, foreclosure sales across the state are held on the first Tuesday of each month. So when the opinion was announced on our website on Sunday at roughly 1 in the morning, a foreclosure sale was reported in the media to have been...
Objection, Mr. President. Any reports in the media would be obvious hearsay and inadmissible.
Sustained.
All right. All I'm going to ask you is, did news reports provide you information that changed your sense of awareness?
Same objection.
I'm not asking you what you heard, not asking you what you read, not asking you any hearsay or anything. Just simply, did news reports later change your sense of awareness, whatever that was?
He's just, excuse me, he's just asking about did it, not what was in them. Overruled.
Yes.
All right. Now, at the end of the day, did whatever that opinion was, did that concern you? And if so, why?
Well, not at the time. It was odd, but it wasn't concerning because at the time I had no context for who was involved or what it was for.
And then once you did have a context about who might be involved, did that change? What was your reaction to that?
It was even stranger that we would have gone through that effort to become involved in a potential Nate Paul related issue involving foreclosure sales.
Okay. Now, after that opinion was done, did you have anything else to do with anything that Mr. Nate Paul and his businesses did, whether it was later bankruptcy or any other events? Did you know anything else? Did you have anything else to do on that front, on foreclosure front, with Mr. Nate Paul or his affairs?
No, sir.
All right. Now, let's go to the final area I want to talk to you about. Was it tell us what your responsibilities were if somebody above you or below you wants to do a contract with an outside lawyer. Let's start here. What was the policy generally of getting outside law firms within the agency? How would that happen ordinarily?
So ordinarily, with an agency of 800 lawyers and 4,000 employees, there are sometimes a need to retain outside counsel. That could be because it's a specialized area of law. Maybe it's intellectual property law, where the Office of the Attorney General doesn't employ IP lawyers. It could also be a local counsel issue. If the state of Texas wants to intervene in a Virginia case, the office would need local counsel. So there are unique instances where we would have engaged outside counsel to represent the agency. All of those requests are managed by the General Counsel Division, which I oversaw in my role as Deputy Attorney General for Legal Counsel.
Well, now, how often in your memory have you ever recall outside counsel being retained to do a criminal investigation?
None.
Ever?
No, sir.
All right. And why is that?
Mostly just because the prosecutors and the attorneys in the office would handle that work.
So when did you first become aware that the Attorney General wanted to hire an outside law firm for a criminal investigation regarding the complaints of Nate Paul?
Well, the first time that General Paxton contacted me, I believe, was in the middle of August of 2020.
And what was the nature of that contact?
He wanted to know what the basic process was to retain outside counsel.
What did you tell him?
I told him exactly what I just explained to this chamber of there has to be a request, there has to be a specific need. The attorneys have to be vetted to ensure that there's no potential conflicts of interest. And there's a formal approval memorandum and a outside counsel contract template that is signed by the attorney and the Office of the Attorney General.
So can we have our exhibit 160, please, Stacy? Is that not in evidence? All right, we moved into evidence 160. Thank you.
No objection at all, Mr. President.
Show 160 be admitted into evidence.
Now, I'll represent, well, you tell me, what is exhibit, do you have a hard copy?
It's on the screen right now.
Okay. Do you recognize what it is?
I do. It's an email from myself to General Paxton's Proton Mail email address dated September 3rd of 2020.
Now, that's a different type of email address than the official Attorney General email route, isn't it, or is it? What is a Proton address?
I'm not sure. I believe it's a private email service.
Well, it's been suggested by his lawyers that that's very frequently used in your organization. Is that true? And there's a Proton email address in addition to your official one, very commonly used with the people in the office.
Objection, Mr. President. Lack of foundation and calls for speculation by Mr. Vassar.
No. They can't do what they did. You heard the cross-examination in this kid talking about how common and ordinary it was and everything. Surely I'm allowed to ask this witness if that's true.
Mr. President,
That's all I'm doing.
I'm sorry, Mr. President, I believe we've invoked the rule and perhaps should not be talking about what other witnesses testified to with this witness.
I was getting ready to say that.
Pardon me?
I was getting ready to say that.
Yes.
Sustained, and you should not be talking about other testimony given in that specific instant.
Well, let me ask you. If one were to contend it is commonly used within your agency to have a Proton email address, would that be accurate or inaccurate?
Objection, Mr. President, calls for speculation.
Your Honor, this is really...
Yeah, overruled. Go ahead.
Thank you.
Not to my knowledge. I've never, not to my knowledge. It would not be ordinary to me. I am not even sure what it was.
Yes, I'm not trying to suggest it's never done, but in your experience, have you frequently or infrequently been dealing with official business in your agency with a Proton email address?
Objection, relevance.
I asked whether he...
Overruled.
Yeah, thank you. Go ahead.
No, sir.
All right.
This could be the first time that I had used that email address for General Paxton before. I hadn't seen it before.
How did you know to use it here?
I think I asked him for his email address that he wanted me to send the contract to, the draft.
The general himself?
Yes, sir.
So are you saying that 5 years you've been there, this email address is the first time you ever used it in dealing with him?
Objection, leading.
I'm asking, just try to be clear.
Sustain the objection, but rephrase.
Thank you. In this particular case, do you recall when he gave you this, how did he ask you to do it, first of all? Did he call you, drop in on you, or how did this happen?
The first time was a phone call when he asked about the basic process for retaining outside counsel. The second, he came into my office on September 3rd, and he instructed me to draft a contract for Brandon Kamek. And
then did he tell you at that occasion where to send it?
Possibly, if I didn't follow up with him to ask him, he could have instructed me in my office on that day of where to send it.
Ordinarily, if you sent it to his regular official agency email address, who would have access to it?
I believe the assistant has access to his email box. I don't know if he had access.
Would this Proton address be on access? Would other people be? Is there any way other people would be aware of it or ultimately run into it? If you sent something at this address, does that become available to others, or would it be only to the user of this email?
Objection, Mr. President.
If you know.
Calls for speculation, lack of foundation, assumes facts not in evidence.
I'm not asking for any. I don't know what facts are not in evidence I have talked about. I simply trying to find out is if this is used, would that then be restricted in availability to the Attorney General? That's all I'm asking.
And Mr. President, what I will renew is my objection that there is no foundation laid for Mr. Vassar to know anything about what the other agency employees can access or cannot access.
Sustained.
Now, when you sent him this contract, did you draft anything in there that was a little different?
Well, I drafted the scope of work.
And when the Attorney General asked you to do the draft, was anybody else around you when he asked you to send it?
No, sir.
Did he describe to you what he wanted this person to get a contract for?
Yes.
What did he tell you?
It was my understanding that Mr. Kamek was being hired as a second set of eyes, if you will, to review the Travis County District Attorney's referral of the complaint involving Nate Paul.
And had you been ever asked to do that in the criminal law area before?
No, sir.
When was the last time you had done an outside agency contract for somebody to do a criminal investigation?
I can't recall one.
Does that mean you don't remember any?
That's right.
All right. So when you did that, did you pay attention to a particular concern as to how to limit the scope of work?
Yes, sir.
Why did you do that?
Well, the referral from Travis County used specific language about providing assistance to Travis County.
Did you look at it at the time, the referral?
The first time I was given a copy of the referral from Travis County was September 3rd.
Were you aware at that time, one way or the other, of any conversations and disagreements that had been occurring internally as to whether Mr. Kamek should be hired to do this? Were you aware through talking to other people or any other source?
Objection, Mr. President. That response would call for hearsay.
I've not asked for the statements yet. I've asked if he was aware of anything.
I'm going to sustain. Would you re-ask the question?
Thank you. So, at that time, were you aware of any other concern about this matter, namely Mr. Kamek being hired to review a criminal investigation or whatever the assignment was? Were you aware one way or the other as to whether there was any opposition by other people in the organization to hiring Mr. Kamek for this project?
Objection, Mr. President. That would be derivative of hearsay.
I have asked simply whether he's aware of...
Overruled.
Thank you.
He can answer.
Are you?
Yes, sir.
Is that another reason you wanted to be cautious?
Objection, leading.
All right, that's fair enough.
Sustained.
Are you? Thank you. Thank you, Judge. Were you, because without going into what you said, had you had conversations before September 3rd with the Attorney General about this matter?
Yes, sir.
When did you have your first conversation with him about it?
The first time would have been when he asked about the basic process. That would have been around August 15th.
And at that time, did he talk to you at all about what he had in mind?
No, sir. It wasn't until the week of August 26th, I believe, when I was on vacation, General Paxton called me and asked me to explain the process, the basic process, to two individuals.
Did he mention Mr. Kamek's name?
Yes.
What did he say to you?
He just asked me to contact both of the individuals, explain the process to them, and that these were the two individuals that.
The other person, why two individuals? Was there somebody else under consideration?
There were two names that General Paxton gave me.
And what was the other name he asked you to prepare a potential contract for?
Joe Brown.
All right. Mr. Joe Brown had been a previous U.S. attorney, had he not?
Yes, sir.
All right. Now, so did you prepare a contract like we just introduced for both Mr. Kamek and Joe Brown?
No, sir.
All right. Whom did you prepare the contract for exclusively?
So the only contract that was prepared in this matter was for Brandon Kamek.
And why did you not do one for Mr. Brown?
Based on when the Attorney General came into my office on September 3rd and directed me to prepare a contract for Brandon Kamek, it was my understanding that there was no longer any need for a contract for Mr. Brown.
All right. I want to take the contract now. Stacy, if you could put up, I moved to introduce 160. I'm not sure I got a reaction one way or the other.
Mr. Hardin, you admitted it.
Thank you.
Yes.
Yeah, it's admitted.
Thank you, Your Honor. I want to move on this contract of September 3rd over to the addendum. Can you go to the next to last page, which says Addendum A? You have that?
Yes, sir.
And is there a portion of this contract and this addendum that you can direct the court and the jury to that will show how you tried to restrict the scope of activity in this contract?
Well, and again, this was all drafted based on my understanding of General Paxton's decision of what Mr. Kamek should be doing, as well as the conversations about the Travis County referral and the extent to which it authorized our office to assist. You can see that the first paragraph specifically refers to certain criminal violations made by state and federal employees. So there's a singular referral that this contract is referring to.
It says, does it not, that this is to be a review of the allegations, correct?
That's correct.
One could review the allegations just by looking at them, right?
That's right.
Object to the sidebar. Move to strike.
It's not a sidebar, it's a question, Your Honor.
You can strike the word right.
Okay. And a review of the allegations, which include complaints of potential criminal violations made by certain state and federal employees. Were you aware at that time of any of the details of what was in Mr. Paul's complaint?
When I drafted this scope, that was the first time that I received a copy of the referral and a copy of the complaint.
And when you looked in the referral, when you looked at the documents that Mr. Paul had provided the Travis County DA's office and that they sent over to the Attorney General's office, what type of allegations did you note as to what type of people and conduct this young man was to look into?
Based on what I recall, Mr. Paul had alleged that certain members of the FBI and the task force, the Department of Public Safety, may have taken his phone from him or not allowed him to contact his attorney. They may have damaged property, searching through evidence. I don't recall the specific nature of the allegations other than just...
Were there allegations about improper conduct by a federal magistrate?
Yes, sir.
Did that give you pause?
It did.
Well, all right. So when you see these kind of allegations, then how did you draft it to try to take care of that, in your opinion?
Well, the last paragraph refers to conducting an investigation under the authority of the OAG, which would be derivative of the complaint, which is to assist. Towards the end of the paragraph, it explains that notwithstanding anything else, outside counsel should only conduct an investigation consistent with the complaint and only as directed by the Office of the Attorney General, meaning that any activities that he wanted to pursue should have been authorized and approved by the office.
And in it, as the way you structured this, do you make any reference in there to this man becoming a special prosecutor?
There's a plain exception that says that the legal services under this contract do not include any other post-investigation activities, including but not limited to indictment or prosecution.
So, as you believed when you drafted this contract and circulated it to be approved by others, what did you think this contract was setting out, giving him the authority to do if it was approved?
In short, he was to review the allegations in the complaint, the statements in the complaint, prepare a report that would be returned to our investigators to provide a second opinion to General Paxton.
And those investigators of yours would have been of who? Who would they have been turned over to?
David Maxwell and Mark Penley. David Maxwell was the director of law enforcement at the office, and Mark Penley was the deputy attorney general for criminal justice.
Did you have discussions with the attorney general that this is what he was authorized to do? Or did you have any, first, did you have any conversations with the attorney general about this?
Yes.
About this restriction?
About the nature of the services that Kamek was being hired for, yes, sir.
What did you say to him?
I just explained that we can't, the OEG, the Office of the Attorney General, cannot ordinarily engage in a criminal investigation except for a referral, a case of a referral. General Paxton explained that he had a referral from Travis County, and then I explained that even under a referral, we wouldn't have an outside counsel representing the agency in a prosecutorial role.
What was his reaction?
He didn't have one that I recall.
All right. And so then, after you have done this, what kind of process it was supposed to go? When you sent this to the Attorney General, did you get a response from him?
No, sir.
Did you hear back from him on this?
Not that I recall. When he asked me to send him a draft of the contract, he also asked me to send it to Brandon Kamek.
Well, so if I can, I move to introduce 161, please.
I don't see this on our list.
I'm moving to introduce it. I believe it's not in evidence.
Okay.
No objection, Mr. President.
Stella, can I have a hard copy, please?
There are no objections. When you receive it, Mr. Harden, you may.
Thank you very
We'll
much.
admit 161 to evidence.
Thank you.
Thanks.
Now, would you identify this for me on September the 3rd? Now, this is, I'm sorry, Your Honor, may I have just a second?
Usually.
Maybe it's.
Mr. Vassar, I want you to look at 161. I want you to look at 161 and see if that is basically the same document that you had sent the same day on September 3rd, except that this one is to Mr. Kamek. Is it the same document?
Yes, sir, that's right.
All right, so now you have forwarded a contract to Mr. Kamek and the same contract to the Attorney General. But what all would be necessary to happen before this became a true contract and Mr. Kamek authorized to work for the Attorney General? What would be necessary?
So ordinarily, when the Office of the Attorney General wants to engage an outside counsel, that has to be approved internally through what was referred to at the time as an executive approval memorandum. That memorandum would explain the background of the request, the nature of the legal authority through which the agency could act, and the amount that was likely to be expended.
All right. In this situation, if you're going to go through the matrix for the contract, would you explain on this type of procedure what would it be the process? How many people would have to approve of this?
I'll run through them very quickly, but generally the process would start with the General Counsel Division Chief. It would next go to the Financial Litigation and Charitable Trust Division. Budget would be next. I believe I would be next in line as the Deputy Attorney General for Legal Counsel. Given the nature of the services involved criminal justice, Mark Penley, the Deputy Attorney General for Criminal Justice, would have been next. I believe Lacey Mays was next.
Well, in y'all's process, does anyone what happens if anyone along that chain refuses to accept it or approve it? What happens?
Basically, the request is denied, but it could be revived based on further conversations.
All right. In other words, everything stops if somebody declines until at least it's talked about more? Is that what you mean?
Yes, sir.
All right. So what happens if the Attorney General goes out and unilaterally hires somebody without sending it through the process at all? In your opinion, could he do that?
Yes, sir.
All right. He has the authority, right?
Yes, sir.
He's the guy. Okay. Now, if in fact, are you familiar with why y'all follow those processes, though, that you've just described that would be in the ordinary situation? Why do you do it that way?
Mainly for efficiency purposes, but also just to ensure that each decision is vetted by the divisions that may have input or advice on the specific issue.
So are the people that are put on there division heads of the divisions that are affected by the contract?
Yes, sir.
So in this contract, what all divisions would be affected that would have to okay it?
The General Counsel Division, the Financial Litigation and Charitable Trust Division, the Budget Division, myself, the controller, the agency controller, the Deputy for Administration, the Deputy for Criminal Justice, the Chief of Staff, and the First Assistant.
It's like 8 people, isn't it?
There's a lot.
Hey, thanks a lot. All right. Now, let me ask you, in the emails that we looked at, or in this document, 161 is a contract, earlier some emails when we looked at 160, 160 is the contract that goes to Mr. Paxton. 161 is a contract that goes to Mr. Kamek. Is that correct?
Yes, sir.
And then you go, if you want, 228, contract 228. Contract, exhibit 228. Well, hold that, please. Don't put that hold on. I'm sorry, Shelley. I apologize. I want to ask you I want you to look at 166. I believe this is already in evidence, Your Honor, because I think it's already been up on the screen once.
Yes, it is.
Thank you very much. 161. Now, I want you to look at this and describe for everyone whether this sets out the approval level it has to be done. Does it?
Yes, sir.
All right. Now, this is the contract that is to be the process to get Mr. Kamek's contract approved, correct?
That's right.
So it starts out with Joshua Godby, the Charitable Trust Division. Why would he have to approve it?
So the Financial Litigation and Charitable Trust Division manage the Office of Attorney General's outside counsel contracts.
Do y'all ever approve a contract that hasn't been the agreement to fund it? Who has to agree to fund it?
The budget division has to approve funding.
All right, let's go up. Then Josh Godby. After him is Ryan Vassar. Who drafted this particular document?
I did.
All right, and how did you know what to put down here under the synopsis and background?
Just based on my understanding, again, of the nature of the services that CAMIC was being engaged for.
Excuse me.
Mr. President, I believe there may be some distrust over whether this document is actually in evidence. We do not object to it. It has not been offered.
Yeah, we're just relooking at that now. So it was not entered, but you do not object. Is that correct? Pardon?
Not.
Okay.
I believe it was shown by an earlier lawyer on your side. I think you had
It was a pretrial
Yeah.
issue that didn't come
We're
in.
good.
But you're good. Go forward.
Thank you very much.
You did not
Joe.
object.
No, thank you. Thank you very much. Now, let's.
Excuse me, for the record, 166 is admitted to evidence.
Thank you very much. Now, so you prepared over on the second page, or it says page 1, but second when you turn it, the synopsis of what happened in the background and all of that?
Yes, sir.
I want you to tell us in your own words, when you sign off and initial this particular contract, did you sign off as if you approved it?
Yes.
All right, why did you do that?
I concluded, based just on my position of whether the agency had lawful authority to hire an outside counsel, Brandon CAMIC, in this situation, that it did.
So you understood who wanted to hire him?
Yes.
Who was it?
General Paxton.
Describe it in your own words that he made clear he was going to do it.
Yes.
So did you have any doubt whether or not that's what he was instructing you to do?
No, sir.
When you draft it, put a synopsis and initial it. Tell us in your own words, what was your position then as to whether this contract should or should not be approved?
So based in my position as Deputy for Legal Counsel, my role was to recommend based on whether the agency had lawful authority to act, not whether it should act. So in my review, I determined that CAMIC, as outside counsel, could provide legal services to the agency to investigate or to review the complaint referred by Travis County.
And what would be your position as to whether he had the authority if he stepped outside the scope that you had drafted so carefully in the addendum A?
Objection, Mr. President. That would call for speculation.
Sustained.
Was he authorized to do more on behalf of the Attorney General's office than you set out in the scope A of the contract?
Not in the draft that I wrote.
All right. Now, when you sent these two contracts, or these proposed contracts, that you've just raised an issue right there. Were these drafts or were they final contracts?
They were both drafts.
So at the time you sent these out to Mr. CAMIC and to the Attorney General, what was necessary to make them a binding contract where the Attorney General's office had actually legally hired Mr. CAMIC? What process was required?
Objection, Mr. President. This actually calls for a very important legal conclusion. And this witness is not qualified to reach that conclusion on the ultimate issue.
I'm asking him what process within his organization was necessary for it then to be, at least him to consider it, a complete contract with the agency. Let me put it that way.
That is a different question than the one you asked.
So I'm going to sustain the first objection. I'll sustain.
But he's allowing the second one. Is that
Well, you can start the second one now.
Thank
One
you.
more time.
All right, thank you. So what was necessary in your mind as the person responsible for both drafting and initiating these contracts to make the drafts you sent to Mr. CAMIC and to the Attorney General? What was necessary as far as your procedures and your experience and in your opinion to make it a contract that would, where Mr. CAMIC was actually officially hired and entitled to be paid under the contract?
Objection, Mr. President. That question is extremely compound. There are several questions in it. Procedures, policies, his opinion may be very different things.
Sustain.
The contract that you sent, had it been signed by anybody?
No, sir.
To be a binding contract as far as you were concerned and the agency and your responsibilities, whom did it have to be signed by to be a binding contract?
Under the agency's signature delegation policies at the time, it would have been Jeff Mateer.
All right. And if the contract at that time was signed solely by Mr. Kamek, do you have a contract, or does it have to be signed by somebody that can bind the agency along with Mr. Kamek?
It would have needed to be signed by the agency as well as funding obligated to pay for
All right.
the services.
So did we ever get to that process that you were aware of at this time?
It was started, I believe June 4th, we started the internal approval process.
And that's the internal process. It's circulating it to the people on Exhibit 166?
Yes, sir.
Just to
All right.
correct the record, the witness said June 4th. I believe you mean September 4. Is that correct?
That's right, September 4th.
I'm sorry?
Let the record reflect September 4th.
Okay. The cover sheet would be 166, would it not? The contract, I believe, were the 164. 161, I'm sorry. I just want to make sure we got it straight.
Oh, I'm sorry. Were you talking to me?
We've got
Be
160.
best to speak to the court. And
166 is what I introduced that you accepted. And that's a copy of the approval sheet. And that's what I was
166 is on the screen.
asking. I'm sorry, that's what I was asking about.
don't talk over each other. Yes, sir.
166 is on the screen and it has been admitted.
You can continue, Mr. Hardin.
I'm sorry, I'm all confused.
166 has been admitted.
Right.
166,
And
correct?
I thought you were changing the number on me.
I'm sorry. I'm confused by your statement. Maybe this would be a good time for a break.
All right.
In about 15
So-
more minutes. About 15 more minutes, we'll have a break.
All right, thank you. So let's try to move through this real quickly. Did it start going through different procedures, and what was the outcome of this contract? Did it ultimately go all the way, or did it stop somewhere along the way?
It stopped
The
along
approval
the way.
process. And where did it stop?
Mark Penley declined to sign the approval memorandum.
And when did you become aware that Mr. Penley would not sign it?
I don't recall the exact date. I recall there were conversations that when I signed it, it would go to Mark Penley next. I advised Jeff Mateer that that was going to be the next line in the sequence. I also advised Mark Penley that he was going to be next after I signed it. I don't recall exactly when Mark Penley declined to sign.
I think there are other documents that we can introduce later that would show that. We'll do it through other people. As to your involvement, Mr. Vassar, how would you view your role once you started sending out the drafts? Did you start having contact personally with Mr. Kamek, where he would have several different requests that you would communicate with him, or what?
I was the point of contact for Mr. Kamek just based on the introduction through General Paxton. After the internal approval process had started, I received a call from Mr. Kamek. I believe it was around the 13th of September.
What did he want?
He asked if there were any official documents or an official email address that we could give him.
And at some stage along the line, were there inquiring about whether he was going to have inquiries by him as to where he was going to have credentials?
I'm sorry, could you say that?
Was he going to have credentials? Did that ever become an issue that would show that he was authorized to work on behalf of the AG's office?
No, sir.
Did you ever provide him any?
No, sir.
Did he ask you for any?
He did on that phone call.
And what did you tell him?
I told him that he didn't have a contract yet. I didn't understand why he needed credentials to identify himself as representing the agency.
All right. Were you aware, what was your level of awareness as to whether Mr. Kamek, or belief, was authorized to be speaking for the AG's office before this process was completed? What was your belief?
He had none. He had no authority to represent the office.
In your opinion, when would he have had authority to represent the office?
When?
Yes.
When he had a binding and executed contract.
And did he ever, to your knowledge, have a binding and executed contract?
Objection, Mr. President. This once again calls for a very important legal conclusion that goes to the heart of the matter.
I'm not asking him for a legal conclusion.
Witness can answer the question if you know of your own personal knowledge, not on hearsay.
On October 2nd, I believe Brandon Kamek sent a contract that appeared to be signed by General Paxton and Mr. Kamek himself.
Do you know when you first saw that?
I believe it was October 2nd.
Is that the first? Describe for us, were you aware before, any time before that, that General Paxton had decided to sign the contract on behalf of the Attorney General's office?
No, sir.
Did you have any idea at that time when you saw it on October the 2nd, how and when that happened?
No, sir.
Did Mr. Paxton ever tell you that he had signed a contract personally with Mr. Kamek?
Yes, he did.
When did he tell you that?
I believe it was Friday in October, which may have been the 3rd. He emailed me and informed me that he had signed the contract with Kamek and that there had been a mistake in Jeff Mateer's letter terminating the contract as an invalid agreement.
We need to jump ahead a little bit for this particular portion. You're aware, or you're not, that, well, let me ask you, do you recall what date you and a group of people went to the FBI to report your concerns?
September 30th.
All right. And are you aware then when you all informed the Attorney General that you had done so?
October 1st is when we notified General Paxton.
And after you informed the Attorney General, did it sometime on either September the 30th or October 1, had Mr. Kamek been sent a cease and desist letter?
Yes.
And whom did he send a cease and desist by whom sent him a cease and desist letter?
I believe Mark Penley sent a letter to Mr. Kamek, and Jeff Mateer sent a separate letter to Mr. Kamek.
And then separately was action taken in the courts concerning the subpoenas, grand jury subpoenas, that Mr. Kamek had obtained and was serving. Was there separate action undertaken by either Mr. Penley or Mr. Mateer?
Mr. President, we object as to leading.
Are you aware of anything? Excuse me. Are you aware of any action that had taken, personally aware of any action that was taken in the courts concerning the subpoenas that Mr. Kamek had been serving?
Mr. Penley moved to quash the subpoenas.
All right. And so then when you get a letter, did you get a letter from the Attorney General? And if so, what date that was, or text?
It was an email indicating to me that he had signed the contract with Brandon Kamek and that Jeff's letter telling Kamek to cease and desist was improperly sent.
All right. At that time, during that first week in October, when we got to October 3rd, what was your status with the agency?
I was still employed.
And had Mr. Mateer resigned the day before, October 2nd?
October 2nd. I believe he resigned on Friday.
All right. When he resigned, had he sent a letter to Mr. Kamek before that, if you know?
Yes.
And at that time, were all of these actions being done with the involvement of each of you deputies that had been called colloquially the whistleblowers?
Yes.
Now, before that, when this contract, what was your involvement as far as the contract for Mr. Kamek once Mr. Penley refused to sign off